So, the federal court system. There are multiple different kinds of cases that are tried in the federal court system. First off, we have to look at jurisdiction. And jurisdiction is the authority to interpret the laws. So basically, there are different types of jurisdiction, and we will look at them in a little bit. But the authority to interpret laws, it depends on what kind of court it is. So you have local courts, who typically have jurisdiction in their area. You have the state courts, which have their jurisdiction in their state. And then you have like the federal level. And so they each have their own jurisdiction, their own authority to interpret laws at their level. So basically what we have to do when we look at federal courts is there are different types of cases that come before the federal courts. And those are the national courts, the ones that are looking at nationwide concerns. So some of these things that are brought before the federal court include things like disobeying the U.S. Constitution. If you are flagrantly disobeying the U.S. Constitution, like maybe denying somebody's right to freedom of speech or their right to bear arms or whatever, that is a way that you can get into the federal court system because that is a direct violation of national law. The second is that if you violate a treaty. So say we have a treaty with some foreign nation and you do something to mess it up. That's going to get you into the federal court system. If you violate congressional law, so Congress passes something and you violate that, that's going to get you into the federal court system. If you commit a crime on a U.S. ship that is at sea, that is a federal crime because it's protected by federal law since it's not a part of a state. Typically, ships don't go into the states. If you commit a crime on U.S. federal property, so that would include like reservations for Native Americans. It includes places that are listed on the national historic places that are old and protected. They're being preserved. Those are federal locations. The post office is a federal location. So if you go and rob the post office, that's a federal crime. Even if it's the post office here in Remsen, it doesn't matter. It's a federal crime automatically. You don't even bother going into the local courts. So, and then the last one is any disagreements between the states. So whenever the states are arguing with each other, it comes down to the federal government, the national government, or the national courts to figure out what the problem is. So when we look at the organization of the federal courts, there are several different levels even of the federal court system. Like I said, jurisdiction has a lot to do with it, and that's the authority to interpret the laws. So you have the original jurisdiction, which is the lowest. It basically means where was the case heard first? Was it heard in Remsen, Iowa? Was it heard in New York? Was it heard at the federal level? So original jurisdiction lies with whatever court heard this case first. And the next level is the appellate jurisdiction. And appellate is the appeals level. So it's the next level. It's the appeals, where if you don't like the decision of something, you can ask for an appeal. They're going to review it and see if anything was done illegally or something that could have skewed it or evidence was entered improperly or whatever. Like I said, there's several other levels of jurisdiction, but these are the two that you are probably going to encounter the most and the ones that you need to really know about. So now we're going to look at the U.S. district courts. There are 3 levels of district courts. District courts are the lowest level. There is at least one district court in every state. And in these district courts, they have jury trials. That's where you have jury trials that are held, where you listen to the case and what's going on and make a decision. They cannot hear appeals case. That is not within their power. In terms of the officials, depending on the district court and where it's located, they can have anywhere between 2 to 27 judges who rotate listening to the cases. Each of the district courts has a U.S. Marshal assigned to it. And so they tend to stay pretty busy. They have lots of things to worry about. A lot of cases coming through all the time. The second type of court are the U.S. Court of Appeals. And like I said, an appeal is where you review cases. And so these courts of appeal are there to review cases from the district courts. And there are 12 courts of appeals. And they also have multiple judges, somewhere between 6 to 28 judges that rotate. But with this, they do not have jury trials. Instead, it's a judge that's listening to both sides, and they usually only listen to the lawyers. The lawyers each get a chance to talk, depending on the state. Usually they get about half an hour. So they get half an hour to present their case, and then the other side gets half an hour to present their case, and then the judge makes a decision. There's no need for a jury in this case, because it's not necessarily, they're not going to make a decision. Instead, they are there to see whether a new court case is needed, if a new court case should be held. So if they decide that, yeah, there was a screw up in your case, they'll send it back to the district courts, and the district courts will retry your case. If they say that there's nothing that happened that was wrong, or you don't have a case for an appeal, then they keep the decision and you just have to live with it. So that's how that works. The next level is the U.S. Supreme Court. And the U.S. Supreme Court is located in Washington, D.C., and they listen to a lot of different types of cases as well, but typically they're looking at things like cases that involve diplomatic representatives of other nations. So if an ambassador or a diplomat from another country comes over here and starts doing some bad things, he will be before the Supreme Court. But mostly what they're looking at are cases involving state fights, state disputes, because somebody's got to make sure that they behave themselves. And the other kind of case that they're looking at are cases involving the state and local governments, that if they're not if the local government's not following what the state has set, or if the state isn't following the federal. So they tend to look at those cases, because those tend to be the ones that are going to affect the nation as a whole. And once it gets to the Supreme Court, all those cases are final. That whatever decision the Supreme Court comes to, that decision is final, and so they can't question it. There's no other appeal beyond that. So, looking at the Supreme Court, the size has been determined by Congress. It currently is 9 members. It's not always been 9 members, but that's where it's at right now. Each of the Supreme Court justices are appointed by the president, and then they have to be approved by 2/3 of the Senate. So it's a lot like the cabinet positions. Most of our judges have served on the lower courts first. They've kind of gotten their experience from serving on those lower courts. But being on the Supreme Court, they have the power of judicial review, which means that when a law is passed by Congress, it has to be in agreement with the Constitution. Otherwise, the Supreme Court has the power to review that law and look at it and decide, is this in keeping with the Constitution? And if it's not, then they find it unconstitutional, it gets overturned, and the law doesn't happen. So they do have quite a bit of power in that respect. Now, when they actually begin hearing cases, it's kind of interesting, because the Supreme Court never starts a case. They never have original jurisdiction. It never starts with them. They serve as an appeals court. Everything that comes to them has already been tried. There's already been a verdict, and they have to decide, was the verdict right or was the verdict wrong? So that's what they do. So they choose somewhere between 100 to 200 cases per year to look at. They don't look at everything, and they don't even look at everything that's sent to them, because they get so much. So they try and pick the ones that seem to be the most important. So they try to pick those that are of significant public interest, things that most people in the nation are going to be worried about, and usually it's a constitutional or a national question. So 4 of the 9 justices have to vote to hear a case, so they don't even need majority. They just need 4 of them that say, hey, I think this is interesting, and we probably should look at it. Now, what they can do is, if a case comes to them, they can refuse it. They can refuse to listen to the case, and they can do one of 2 things. When they refuse it, they can determine that the lower court's decision remains, so they're not going to do anything. They'll say, like, the district court's decision or the Florida Supreme Court's decision is going to hold, or they're going to be remanded. And when they remand a case, they are returning it to the state where it came from for a new trial. basically saying something was wrong, something got messed up, but we don't want to deal with it, so the district court's gonna retry this, and then we'll see what the decision is after that. So they can do that if they refuse a case. For the ones that they do listen to, the court begins its action. It goes into action on the first Monday in October. And so it begins its session on the first Monday in October, and they typically work on it until Thanksgiving, and then they start up again in the spring. But they read the arguments, they hear arguments, so they do a lot of reading and research before they even listen to anybody. But then they hear arguments, they have the lawyers come in, and like I said, the lawyers get like a 30-minute time limit where they present their case. And then they hold a lot of private meetings. They don't make a decision right there. They ask questions, and they hold private meetings with each other, and they do continue to do the research on looking at papers from the Founding Fathers, looking at the Constitution. A lot of things help them make their decision. And then they vote, and then the majority vote wins. And sometimes it's unanimous, and sometimes it's not. Sometimes it's very close. Sometimes it's a 5-4 decision. But whatever the majority is, that's what the decision is. So the Supreme Court, after it does its vote, will issue opinions. One justice who is in the majority writes a basic synopsis of the case and how the court came to the decision that it did, and that's called the majority opinion. So the majority opinion comes from one of the justices who writes it all out of, this is why we decided the way we did. This is what we found in the Constitution. This is what we found in one of the Federalist Papers, or whatever it is, something that is going to help explain why they got to the decision they did. And then someone who is in the minority is going to write a dissenting opinion. And the dissenting opinion is basically the same thing as the majority opinion. They write it up. But what they're going to do in the dissenting opinion is write about why they disagreed with the majority decision, on what points. Because sometimes it's very touch and go. Sometimes they don't always agree, and so they each have valid arguments, and so they want to have that available, so in case a case like that ever comes up again, they can look at past decisions and see how that they came to those decisions. So that's why that's important.